Hey, welcome to All Things Social Security. You're about to see a question from a live viewer and my response, and it may or may not have an attached additional set of information for you, but you'll see a little invitation to that if that's the case. If what you're looking for is representation and you want us to take a look at your claim, please go to joydisability.com and look in your upper left-hand corner for the link for the free SSD evaluation. And we will take care of that for you. Thank you so much. Bye-bye. Enjoy the video. Good morning, afternoon, or evening. Okay, here's another share, guys. Saw this today, and I think it might be helpful. This has to do with filing for DAC benefits for your adult disabled child when you, for instance, retire, something you got to remember to do, or become SSD disabled, something you have to do. And again, that's for the particular kind of disabled adult child who was disabled before the age of 22. And that's something that has to be proven. Okay, so Eldon asks, I have a mentally disabled adult child diagnosed shortly after birth. When I filed for my SSA benefits in 2018, I didn't know to include my child. When I went back and asked recently, they said it's too late. Is this true? I'm going to say no, Eldon, that's not true. It is not true to apply for your adult disabled child right away. And I believe they might get up to 6 months of back benefits, but it is too late if what you're talking about is, can I get all those back benefits, or can he or she get all those back benefits going back to 2018 when I first applied for my own? No. And what's kind of infuriating about this, and I don't know why this is, it's been this way as long as I can remember. When somebody, including Eldon, applies for Social Security benefits, this would be for sure with an SSD claim, but also for a retirement claim. It asks if you have dependents. And it asks if you have any children who were disabled before the age of 22. If the SSA is asking for that information, one would like to think that the onus is kind of, since this is a social welfare program, and I should take that back, a social program, not per se a social welfare program. Don't want people to conflate it with SSI, which is truly a social welfare program. SSD or SS retirement is a earned, worked, and paid for insurance policy by the workers themselves, such as Eldon. Okay. If they ask for that information, why on earth are they not saying ding, 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 and really, really follow up with the person to make sure they apply for DAC benefits for that child at that time? It's probably been the policy of the SSA forever, and still is, to, well, let's not totally sell the farm, you know what I'm saying? Like, people have a responsibility to look into the law themselves. And I get all that. I don't think they should necessarily be hounding anyone down and spending money going finding them wherever they might be on vacation. But how about just a letter? And now that we have online portals, how about a note in there saying, it is possible, it's not clear, but it's possible you might have a disabled adult child who could get benefits under your record, which in no way take away from your benefits, mom or dad. It's in addition to, and just give them the notice, constructive or otherwise. I don't know why they don't do that. It's been something I've thought about for 21 years now. Okay, Eldon, you can apply now for your child. It's not too late for that. You are collecting benefits. Your child is presumably a DAC. Eldon does say, I don't know if I mentioned this, that his adult child was diagnosed with whatever the impairment is shortly after birth. Now, of course, Eldon doesn't mention, but I'll bring it up. Was that child on any kind of, was he on SSI as a child? That would only be if Eldon and the other parent were, very financially strapped in terms of the federal poverty rate. If they were near indigency for the standard of any given year, then the child, one would apply for SSI because the child is disabled, and then that, $900 and something the child could feasibly get, which helps the parents care for the child, of course. If that didn't happen, which it doesn't probably for the majority, I don't know. I don't know percentages. I'm throwing it out there. Probably most parents who work hard and make enough income to support their family, disabled or otherwise, don't have that SSI option. And honestly, it's probably better that they don't. The problem comes in if the child was never, it's not a problem necessarily, it's just a hurdle. If the child was never disabled in the eyes of the SSA until now you're asserting it, because now there's a claim he could feasibly, be under, you still have the onus of proving that he was disabled before 22. So just from a practical point of view, you're going to want to get all those IEPs, everything from the schools, all of the diagnoses stuff from when he was a child. And that is really hard because a lot of things were destroyed, after 7 years. I remember back in the day, they'd always tell us that there was a fire, warehouse fire, even if it was less than 7 years because they didn't keep proper records. And so there was a lot of fires going on. You didn't see them on the news and there was no evidence of it, but that was always the claim. Now with digital everything, you would think that wouldn't be even an option. But back when this child, I don't know how old your child is, was, a youngster, those records may or may not be available. So I would scramble. I would be very creative thinking of how I could find out when and where they might be if they still exist. Because you have to prove it's before age 22. And sometimes those childhood records are the biggest way of showing it was really, really bad since way back when. If not, it could still happen through maybe the child, I don't know what the impairments were, but maybe there was all sorts of occupational therapies and all that stuff all the way through high school. Maybe still. What do the records say between 18 and 22? Is a practical reality that oftentimes, from birth, severe disabilities are not curable. And sometimes there's not even like a hefty treatment thing. There could be mild treatments, right? There's certainly checkups and the diagnosis is there, but we're talking about the evidence that would show how severely limiting somebody is. If the another thing to look at, Eldon, is if the child's impairment was it a compassionate allowance type of listing? That is kind of based mostly on diagnosis itself versus a regular listing, which the diagnosis must be there, but then most all of the criteria that shows that that person's version of that impairment noted in the listing is of the severe kind versus all the other people with that diagnosis that have it mildly. So there's compassionate allowances is when the diagnosis itself almost implicitly says it's extremely disabling. The mere diagnosis of it is disabling, whereas the ones in the listings, the regular listings, not so. But that's another thing to look at. School records, all those things from 18 to 22. You don't mention how old the child is, so I don't know how far back you might have to go. Like, let's say your child's 35 now, or 40, and you're, 67, or we're in 2018, whatever the case may be. But someone in Eldon's position has to have really robust records to prove that it was disabling. So it could be under the childhood rules and then also provable under the adult rules, or just under the adult rules from 18 to 22, because you don't have to prove it back to childhood, like little itty bitty years. You only have to prove it was before age 22. And, the rules are different for a child when the child's a child versus what you have to prove when the child is over 18. So anyway, I hope that helps, Eldon. But yeah, if I hope they didn't say it's too late and he can't get any, because that would be false. So if that was the case, I'd get right on that right away and file, but you need to hustle and get those records to back it up, or else you won't be able to prevail. And don't think you can do it, run it, not get all the records, lose, and then try again. You cannot try again, because once it is, the rule of your case that it was found by the SSA all the way up through an ALJ judge in particular to be disabling under the rules, or to be not disabling under the rules, you can't go flip that as a general rule. There's some rare exceptions, but not just because I didn't get all the stuff I should have gotten in. So, all right. God bless you, Eldon. I know it's been a probably a major part of your life caring for a disabled child who's going to be disabled forever. So I appreciate you. and keep up the good battle here. Alrighty, everybody have a great one. I hope to see you at Social Security question and answer live stream tomorrow at 1 p.m. Eastern Standard Time. It might not be tomorrow for you when you're seeing this, of course, but every Wednesday. I'll talk to you guys later. Bye-bye now.